Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, I am coming to you from Washington's nicest indoor shooting facility, Security Gun Club, right here in Woodinville, Washington. But I do want to talk to you about a case that took place in Delaware last week, but there's a very disturbing trend that's coming from it, and I think it's one that we all need to be aware of. As we know, when people used to ask me all the time, how is that law constitutional? How can they ban that? How can they ban magazines? How can they ban assault weapons? The answer always was, well, there was this two-part balancing test, and it really just allows judges to put their thumb on the scale. Well, that was eliminated in the Bruin opinion, or so we thought. But there is a recent ruling out of Delaware that is beginning to show a new playbook for how liberal justices are going to want to make sure that your God-given rights are deprived of you. So today, let's get you all educated and get you up to speed on a disturbing new playbook to argue assault weapon bans are constitutional. Okay, before we get going too far down the road, I want to thank the inspiration for this story, which is an article I read on The Reload. Hey, if you haven't checked out thereload.com, check them out. They are doing a fantastic job of objectively covering Second Amendment issues on a nationwide basis. So please check them out at thereload.com. Okay, some of you may have heard about this last week, but as you know, there was a ruling out of a federal district court judge in Delaware. There was a challenge to both Delaware's assault weapon ban as well as Delaware's magazine ban. Many of you in some states are dealing with this exact issue, either in current law or current legislation kicking around your state capital. The judge, Judge Richard Andrews, applied the law almost correctly and came to the wrong conclusion. Now, let me explain what I mean. As we know, under the Bruin analysis, the old two-part test, that is, does it infringe upon the rights? Yes, but if it does, then we're going to do this balancing test between the individual rights and the societal needs. That balancing test has been wiped clean. And so therefore, we go back to much more simple rules, such as the common use test. The common use test was developed in Heller. It basically says the Second Amendment protects the types of firearms that are in common circulation today for all lawful purposes. Put in other terms, when we go back and we look at historical analogs, what it really means is that the only historical analog that we have as a nation is we have traditionally allowed for bans and restrictions on firearms which are deemed both dangerous and unusual. Now, since we're talking about standard capacity magazines, which are not unusual, and we are talking about the most common sporting rifle on the planet, again, not unusual, a proper analysis, a proper application of case law would say that, hey, you know what? These both fall under the common use doctrine, therefore any ban or infringement upon it is per se unconstitutional, and they are struck down. Judge Andrews ruled that both assault weapons and large capacity magazines do fall under the common use doctrine. Let me say that again. He found that they fall under the common use doctrine. However, what Judge Andrews also found is that the founders could never have envisioned all of the technological advancements that could be made in the firearm industry, would have never envisioned the scourge of mass shootings that we suffer from today. And for that reason, the court was allowed to engage in further balancing to determine the legitimacy of these laws. And using historical analogs, which regulated Bowie knives, and billy clubs, Judge Andrews found that there had been a rich tradition in this country of regulating instruments and weapons that could be used for large mass chaos, mass injury, mass killings. Now, understand that Judge Andrews is not alone in that, because Judge Karen Ermiger, a federal judge in the state of Oregon, used that exact same analysis in upholding one of the many challenges to Oregon Ballot Measure 114. That means we have two justices now on the federal level that have basically said, yes, I understand that this is part of the common use. However, I'm going to engage in a balancing test that the Supreme Court has already told me we don't get to engage in. In issuing his ruling, Judge Andrews actually found that the burden to the plaintiffs, the infringement upon the plaintiffs, was real, but only slight. And that alone explains that the judge is engaging in a balancing test, because where along that sliding scale of infringement upon the rights, Judge, do we go from constitutional infringement to unconstitutional infringement? And that's the beauty of the Bruin opinion, because the Bruin opinion says, listen, if we go through the first part, which is, has there been an infringement of right, whether it's a grotesque infringement or a slight infringement, it's an infringement nonetheless, and that's the end of inquiry. The other problem with this analysis, and why even if you do not support gun rights, you need to be concerned about this, is that the judge reasoned this entire opinion on the fact that these weapons can be used to create mass chaos, mass injury, mass death. If that is the standard by which we're going to allow government to regulate and or ban inanimate objects, recognize that that will not be limited to firearms alone. There are other objects that can be used in exactly the same destructive manner. The baseball bat, the kitchen knife, and the automobile are three that come to mind. So listen, I want you guys all to be aware of this, because one of the things that I've noticed in the last few years here with Washington gun law is that when there is a liberal gun grabbing idea that picks up steam somewhere, it is only a matter of time before that idea is cut and pasted and dropped in various other jurisdictions. There is no doubt in my mind that this exact ruling from Judge Andrews will be cited as nauseum now by government attorneys trying to promote the effectiveness of gun control legislation. On review, if this case is analyzed using the correct legal analysis, it will never stand the light of day. It will be overthrown because this judge has essentially gone one step too far, exactly what Justice Thomas told you not to do. The case, once again, is Delaware State Sportsmen's Association, Inc. versus Delaware Department of Safety and Homeland Security. We will put a link for all of it down below so you can track it. Again, it's a really important case because this is a disturbing line of reasoning and we need to carefully watch it. Listen, you may have more questions about this or anything else related to what's left of our Second Amendment rights. You guys should know how to contact Washington Gun Law by now, but if you don't, hey, all of that information is in the description box down below. In the meantime, I want you all to remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.